Thank you, Madam Speaker. And I rise to contribute on behalf of the Greens to the Crimes Administration of Sentences Amendment Standard of Proof Bill 2025 and say at the outset that the Greens stridently oppose this legislation. Our spokesperson in the other place, Sue Higginson MLC, made great efforts to try and work with the government on this with amendments, but basically that we got a couple of minor amendments, but it's really, really serious, and I want to go through all the reasons why we don't. But Madam Speaker, one of the things I want to say that in terms of the context of this sitting week is that we have seen some hugely impactful legislation, particularly with relates, not this bill is one that it's come back that's huge, but in particular one that we will debate shortly, which is about the Dolly Incapax, which is about the criminal age of responsibility and the law, the codification of the common law. And that is, we are changing something that has been in place since the 1800s. But we were basically given that bill this week, and we're debating it today. What we're seeing more and more, and what I want to raise in the context of this legislation, is it's a complete lack of engagement, detailed engagement with actual stakeholders. And the case in point with this piece of legislation is that we were told that the Aboriginal Legal Service, so let's just put these things into context. So what this bill actually seeks to do, and I'm basing this purely on the second read that happened in the Legislative Council. So just to repeat, we oppose and we will be dividing on this. This bill amends the Crimes Administration of Sentences Act 1999 to change the standard of proof for determining correction centre offences from the criminal standard of beyond reasonable doubt to the civil standard of the balance of probabilities to find guilt. Division 6 of this Act sets out the framework that includes the standard of proof and penalties that can be imposed for correctional centre offences, ranging from minor offences through to criminal conduct. And we know that with this piece of legislation that people can still be referred to a magistrate and to the criminal justice system outside of the prison. Governors or delegates currently have to apply criminal standard of proof that when they are assessing whether a person, an inmate, is guilty. And the Minister is arguing, and this piece of legislation is arguing, that these are administrative in nature. Because, of course, we know that in administrative law, the balance of probabilities as the standard of proof makes sense, and the argument is that basically that the governor in a prison is making an administrative decision. What we also know is that deaths in custody, Aboriginal deaths in custody, this year reached an appalling landmark, and that landmark was that as of a month ago, 12 Aboriginal people had died in custody. And we have seen so much work, it's uncontested, royal commissions into deaths in custody, inquiries in this parliament, and we know all of the things, and including the recent New South Wales, the August 2024 New South Wales Ombudsman investigation into inmate discipline in New South Wales correctional centres. And what does that all tell us? What it tells us is that the status quo is not only not working, but has been accused of complete maladministration, of complete breaching of human rights, of a raft of appalling outcomes, unjust, widespread maladministration in the status quo. And what does this minister want to do? The minister wants to lower, so accused of maladministration, not just by us, by the New South Wales Ombudsman, in prisons, rife across prisons in New South Wales. And what do we want to do? What does this minister want to do? Lower the standard of proof when the Ombudsman has gone through all of the reasons of why the system is failing inmates. Now, we know what we've been told is that the only person, in terms of going back to consultation, the Aboriginal Legal Service, which you would think is a major stakeholder, were not So basically, we were told that they were not aware of this legislation until it was tabled. That is not the way to do this work that affects people's lives, that it affects the death of inmates. This is absolutely unacceptable. Labor said in the debate that the Aboriginal Legal Service had provided feedback on the bill, but we were reliably told that they did not know about it until it was introduced. Madam Speaker, First Nations peak bodies, university law schools and legal experts have been critical of the Minister for progressing this law that will worsen the risks of deaths in custody following the New South Wales State Coroner's rare statement criticising the worst year for First Nations deaths in custody on record. In an open letter, First Nations peak bodies and law experts warned, and I quote, that incarcerated people subjected to discipline proceedings who are locked in solitary confinement, fined and deprived of basic privileges like phone calls and visits with loved ones are at increased risk of acute and ongoing mental and physical harm and even dying in custody if these laws pass. Because the reality is you're asking the head of the prison to decide on the balance of probabilities whether an inmate should be locked up in solitary confinement, deciding, being the jury and judge of that inmate, to a standard which already happens, but to a standard. So on the balance, on the beyond reasonable doubt, even with that standard, inmates are not allowed to provide evidence. They are not allowed to seek legal counsel. So they're already utterly disadvantaged. Changing it to an administrative law standard of proof is just outrageous. Madam Speaker, New South Wales Labor needs to take the deaths in custody crisis seriously. And that means sitting down with First Nations people and experts to hold our prison system accountable for lawlessness and harm. We understand that there are prison officers that are being assaulted. We understand that those things occur, but this is the wrong side of the equation in our view. Madam Speaker, when in the open letter of which we signed, we saw that the Ombudsman's recent report exposed that corrective services employees were systematically violating their obligations to notify governors and health professionals of punishments being imposed on incarcerated people. This is something that that people around the world watch and are appalled by. 1 in 3 charges laid during disciplinary proceedings were completely incorrect, according to the Ombudsman report. 75% of incarcerated people penalised for correctional centre offences had vulnerability indicators, including disability or mental health issues. 43% of incarcerated people penalised for correctional centre offences were Aboriginal. It's nearly half. In particular, young Aboriginal men were repeatedly confined to cells as a result of proceedings in contradiction of the custodial operational policy and procedures and the recommendations of the Royal Commission into Aboriginal deaths in custody. 80% of the cases where the defendant pleaded not guilty contain no record of reasons for the subsequent guilty finding. So those governors are not having to they're not even explaining their rationale. How is this allowed in the 21st century? 70% of charges were not finalised until after a guilty verdict had already been determined. This is not a culture that we should stand by and allow to continue. It's so disappointing that the Minister, in looking at all of the recommendations from the New South Wales Ombudsman investigation into inmate discipline in New South Wales correctional centres, that this is the result of that. You cannot have read the findings and recommendations from the Ombudsman and seriously consider this piece of legislation. Madam Speaker, we have an obligation to ensure the safety of people who are serving out their custodial sentences. There are so many things that I could talk about, but it is unreasonable and unjust and otherwise wrong, so many parts of what is happening to inmates. And these are the findings of the government's own, you would think, to listen to their own New South Wales Ombudsman on on this matter. Madam Speaker, we stridently oppose this. We did get the amendments around record keeping, but so many of our amendments were lost, and it's terribly grave indeed.